Greetings of the day, everyone. I warmly welcome you all on behalf of Vidhi Sanskaar to today's session on the future of ADR and ODR. We have with us Dr. Shivangi Sinha, lecturer at Bharati Vidyapeeth, Deemed University, New Law College, Pune. Now, I would like to hand it over to Dr. Shivangi Sinha ma'am to begin the session with. Thank you.
Thank you so much. Thank you so much to the organizers. Just give me a second and we'll quickly start with the session. Okay, to begin with, I would first like to thank all the organizers for actually having this particular session on one of the, I would say one of the most discussed topic in today's time period, and that is with respect to the future of ODR and ADR, which is something which we are talking about, on a day-to-day basis. And I believe everyone whosoever is present is quite aware, or a bit of awareness is already there with respect to this topic. So what I'm going to do is that I'm not going to draw a very detailed line of what particular ADR is, what particular ODR is standing for. What I'm going to do is that we are definitely going to discuss the conceptual overview along with its future standing. Now, to begin with, as we all are aware that ADR is something which is known as alternative dispute resolution, and this is one of the method of resolving dispute which is outside the traditional courtroom. So we are not following the protocol, the traditional approach which we go into the court, having all those procedures. We're not doing that. Rather, what we are doing is that we are trying to resolve our disputes out of the court with the help of a third party. Now, when I say third party, there are a lot of different aspects related to this particular third party, and there are a lot of different concepts which is coming under the picture of alternative dispute resolution. To speak about it, we have arbitration, we have conciliation, we have mediation, we have negotiation, we have local adalats. These days, we are also dealing with blockchain technology. We have the MIDA process, we have fast track arbitration, and there are so many different things. Now, when I speak about alternative dispute resolution, and I'm saying that, it's a process of resolving disputes alternatively, that is outside the traditional courtroom setting. So this is basically not a new concept. So if we go into the historical part, or if we go into the jurisprudential part, we can see that this particular term, arbitration, okay, it's having its existence from a very prolonged period of time, no matter whether we are talking about the Indus Valley civilization, or we are talking about the Mughal emperors, or we are talking about the Gupta emperors. No, you can just correlate this particular term of resolving the disputes all over these dynasties as well. Even in our Vedas, okay, even in our Vedas, this particular aspect is present. Now, the best example which I can give you that this is not a new concept, rather it's just an, I would say an old concept with a new cover, is our panchayat system. You can see the Constitution of India. I think most of you, I believe, will be from the legal background. And when we are from the legal background, then you might be aware of these particular terms. Okay. Now, panchayats, again, the concept says the same, where the people, where the third person or the punts used to listen to us and try and understand that what is the understanding of the situation and gives the solution to it. So what I'm trying to say that I'm trying to draw a nexus over here, right from the people sitting under the tree to now people sitting as an arbitrator and trying and understanding what is the concepts all about, is something we are studying, and we are studying something which is beyond the traditional system. So that is the overview concept of alternative dispute resolution. Speaking about the ODR, okay, now this concept of ODR, you can say that it is a digitalized evolution of ADR. Okay, it is using a technological platform to facilitate the dispute resolution through online mechanism. It can be done through video conferencing, it can be done through online filing, it can be done through e-negotiation, it can also be done through the latest AI enabled mediation tools. Okay, and this is very useful when we talk about the e-commerce sectors, when we talk about the consumer grievances, when we are talking about the medium and small enterprises, when we are speaking about the cross-border matters. Okay, now the first question which pops up to to in everyone's mind is, we already have a set system of judiciary. We already have a litigation. Why are we even talking about ADR? Why are we even discussing about ADR? And why are we even attending the session of knowing the future of ADR and ODR? Okay, so why are we actually doing this at the very first place? So the most importantly, it tries and reduce the burden of the court, because most of your matters are shifting to these kind of concepts. So the pendency of litigation or the pendency of so many cases which has been there, it is actually getting reduced. Okay, this is also giving you a very speedy justice. So we always say now that there has to be speedy justice, because if you are delaying the justice, that means you're denying that particular justice. That should not happen. So this is trying to give you a speedy justice. Most importantly, there is one term called amicable settlement. Okay, so these concepts, when I'm talking about mediation, when I'm talking about conciliation, they're trying to promote these amicable settlement. So this is very important. This amicable settlement, directly or indirectly, is actually enhancing the access to justice. So that is the most important concept, that why these days people are actually talking about arbitration, people are actually talking about mediation. Why are we even having mediation act at the very first place? Why are we even discussing something which is just related to the technology, that is your ODR? Okay, so that is the basic understanding. Obviously, everything has the two sides of the coin. So even these concepts, when I'm talking about ADR, ODR, and all different concepts, they also have various loopholes attached to it, and there is so many things which we are still working on. But at the same point of time, we should understand the overview. We should understand that yes, of course, this is the importance of these concepts, and that is the reason we are here to discuss its future today. Now, the most important thing which comes to the mind is that people don't go and opt for private processes. They say that we don't have the legislation, we don't have any kind of authority. Why at the very first place we should go something which is very private in nature? Even if I'm going to get a solution to it, can I actually stand by it? So the first thing which we need to understand is that we need to see that what are the legal frameworks which run across. Now, when I'm speaking about the statutory provisions, when I'm speaking about arbitration, mediation, conciliation, we can definitely come across the Arbitration and Conciliation Act of 1996. Okay, now when I'm talking about Arbitration and Conciliation Act of 1996, this is incorporated from the Ancestral Model Law, and it tries to cover all the arbitration and conciliation process. Now, again, landing up to Arbitration and Conciliation Act of 1996 is again having a huge history behind. Okay, that how the system was there, how the Britishers came into picture, how they actually tried to give a statutory understanding of these kind of concepts, where we can actually resolve the disputes by using the help of certain laws. We had Bengal Regulations Act, then there were some presidency towns, we had separate legislation, then everyone landed up with Arbitration and Arbitration Conciliation Act related, which was in the year 1940. Then we got to know that there are so many things, because of the societal changes, there are so many things which has to be adapted. Just in the same way, like now we are studying a new criminal manual. Okay, instead of IPC, we are studying BNS. So in the same way, at that time, the society realized that there has to be some changes which need to be brought across with respect to these Arbitration and Conciliations Act as well. So we landed up with Arbitration and Conciliation Act of 1996. So every point which I'm putting down here is having a certain nexus and an history attached to it. So what we are going to do is that obviously we are not going to the historical perspective. We are talking about the future. But in order to build the future, it is very important for us to even know that what was the past and where are we standing today. So that is also very important for us to acknowledge. So that is the reason I'm just giving you the present scenario and I'm drawing a nexus behind it. Same if you see your CPC, Civil Procedure Code. Over there also, if you will see section 89, it tries and mandates courts to refer cases to ADR. Okay. I mentioned about Lok Adalats. So Lok Adalats have your, it has been governed by your Legal Service Authorities Act of 1987. When I'm talking about disputes, so many disputes are going to mediation and conciliation. What kind of disputes? Basically the corporate disputes. Okay, so if you will check with Companies Act, specifically section 442, you will see that they try and refer the matters to mediation and conciliation panel. Now, another question attached to it, that why are we emphasizing more on the corporate dispute? Now I'll give you the reason behind it. The reason is very simple. When there are two businessmen, or when there are two parties or two companies which are coming together and they want to do a business, okay, and if there is any kind of dispute, because that is a scenario which can happen, you cannot go without dispute. There are situations where conflict do take place. So when you are doing a business, you will actually want to get it resolved as fast as possible, because when we are talking about business, there is a huge amount of money which is also being involved. So people don't want to waste their money, they don't want to waste their time. And when they go for litigation, they are very much sure, undoubtedly, even if they go to the quasi judicial body, even they go to NCLT, they are very much sure, they're pretty much sure that they're going to a lot of time which is going to be enhanced in that particular process. So they are not very sure that where this dispute is going to end and where this matter is going to end and how far and when are we going to take this business forward. So these corporate conflicts, I would say that alternative dispute resolution could be the best mechanism for that. So therefore, when we are talking about these conciliation panels, when we are talking about these mediation panels, so these corporate disputes are actually being handled by them in a very, I would say, in a positive way, and therefore where we land up is with something, a positive and affirmative reply, so that people can take their business forward, keeping their corporate conflicts aside. Okay, so that is also one part of it. Now, speaking about the statutory recognition of ODR, so you don't have anything persistent to your online dispute resolution act or something of that sort, but you can actually see the nexus everywhere. Like for instance, if you're talking about Information Technology Act 2000, so it provides legal recognition to all the electronic records and the digital signatures. Now, when I'm speaking about electronic records and digital signatures, I very well mentioned that when we are talking about ODR, ODR carries the performance or the essence of arbitration in the digitalized platform. So when we are bringing digitalized platform into picture, that means we need to have a stability with respect to a legal recognition of the electronic record. We need to have a stability with respect to various digital signatures which takes place. And therefore, their Information Technology Act 2000 plays a vital role. Okay. Speaking about bringing technology in arbitration, so if you will check the different amendments which has taken place in the year 2015, in the year 2019, in the Arbitration and Conciliation Act, you can see that these amendments, inclusive of the Law Commission report, have recognized the use of technology in arbitration. Moving ahead, there are certain Supreme Court e-courts projects also which has been taking place, especially after the COVID time period, where they have integrated the virtual hearings, where they have integrated the concept of online dispute resolution in their daily mechanism in order to resolve the disputes. Okay, so just in order to compile what I have said right now, so I have just given you a nexus that how ADR and ODR are important, how ADR and ODR hold importance in the field when we are talking about different kind of conflicts, and how they are also giving us a kind of statutory recognition which people think, okay, that is something which we lag behind, and that is something which we think about, and we say that we don't have a particular forum, we don't have a legal recognition, should we really go and opt for this process? So what I'm trying to give you, that I've given you the conceptual analysis of ADR, I've given you the conceptual analysis of ODR, I've given you that yes, of course, these are the present legislation which is there. So you can get the legislations from here. So at that point of time, you cannot say that, okay, we don't have a proper law for it. We do have. The only thing is that you need to interpret it in a different form so that the execution can be easy for it. Okay. Now we can have the best illustrations for it. Okay, like for instance, I can take some examples with respect to the case laws which has taken place. You have one of the very famous case of Afcon Infrastructure Limited. Okay, it's a case of 2010, where the CPC itself mandates and say that these kind of civil disputes you can actually go and refer to ADR. Okay, you have a very famous case of Booz Allen Hamilton. It's a case of 2011. This basically points out that only matters which are arbitrable in nature. I request everyone to kindly mute yourself. Organizers. Okay. And just one more request. If you're not using, then you can please turn off your mic and your cameras as well, because that's a kind of distraction which takes place while speaking. Organizers, if you can just see to it that all the cameras and mics are being switched off or being muted on mute. Thank you. Okay. So Afcon infrastructure, I just gave an example where your section 89, okay, mandates that the civil disputes can go to ADR. Then there's another case of Booz Allen Hamilton. It's a case of 2011 where the court specifically says that what are the matters which can go for arbitration. Okay, so they have given it very beautifully, and they say that the matters which are not of very serious nature can go to arbitration, and the matters which consist of some provisions where we need to have certain kind of provisions, like for instance the criminal matters, that should be tried by the court. Reason being, in arbitration we don't give kind of punishments on anything. We don't have those kind of punishments. And when uh, anything which involves right and rem, when you're doing anything which is with respect to the society, then obviously you need to have legislations. You need to get it governed by certain things which actually recognizes it. Okay, so this case was very important, and they gave a very good nexus that what are those matters which can go for arbitration. Howsoever, if you will see today in today's scenario, there are so many things which are related to insolvency is also going for arbitration. Okay, another illustration I can give you of one more case law, that the Salem Advocate Bar Association. Again, Section 89's constitutional validity was being checked there, and even they, stressed upon that ADR should be used in order to reduce the judicial backdrop. So what I'm trying to say over here is that we are not saying that just go for ADR. Okay, we are saying that, okay, fine, we are following the traditional method. People are going for litigation. We are trying to resolve our disputes with litigation. Undoubtedly, we should also see that what are the scenarios and what are the circumstances where we should actually go for these alternative dispute resolution process, which is going to be no doubt helpful for us, and it is also going to reduce the burden of the judiciary. So I've given you certain live case laws, some examples, okay, which basically says that yes, of course, we need or we should go for these things. Now, quickly moving now, since I've given you a nexus of what is ADR, what is ODR, so we'll try and discuss more towards its future objectives. Okay, what are the future trends? What are the future prospects which are being related to ADR, which are being related to ODR in India? Okay, now when we are talking about the trends and prospects, so there is numerous government push which is being done. Okay, if you will see, then there are so many initiatives which are being taken by the government. For instance, there is ODR policy plan, which is being done by Niti Aayog in 2021, where they are trying to annex, okay, or integrate the court system with the ODR policy. Okay, there are different startups and platforms. Like for instance, there are certain platforms which I actually want to mention over here. For I've got I was fortunate enough to even work with those startups and platforms which are dealing with ODR, like Resolve 360 or SAMA or Center for Online Dispute Resolution, that is called. All these startups and platforms are working very beautifully, and they're actually enhancing the use of ODR. Okay, Nationwide, the governments are actually trying to digitalize the use of judiciary. Okay, so basically there is expansion which is happening in e-courts. They have also inculcated one more important thing, that is mandatory pre-litigation mediation. Okay, and it is also being mentioned in the Mediation Act of 2023, where you need to have a compulsory mediation before certain civil suits. Now, what is happening when you go for mediation and we try to do mediation before you go to the court matters or before you reaches to the court, there are some high probability or there are some high chances where you can actually resolve the disputes even beforehand. So this is obviously a greater nexus which is joining hands with the future justice, right? So if suppose if I'm having a dispute with any XYZ person, and in a very optimistic way, we always say that we'll see you in court. So if I'm telling that person that I'm going to see you in court, and before even reaching the court, I'm trying and getting that matter resolved beforehand, I think nothing like that, right? So what I'm trying to do over here is that I'm trying to give you the perspectives of these technologies into a very lucid form, not into a very technical form, so that it's easy for you to understand. And because when you are attending this session on a weekend, there has to be some takeaway from it. Okay, taking this particular discussion forward, after Mediation Act 2023, there's one more thing which the government is pushing across, that is the cross-border utility. Now, we all are aware that how much trade is important for us. Okay, these international trades are very important for us, and we need to have a very neutral shift forums, okay, which is very essential in order to resolve these things. Because when we are talking about cross-border, we are talking about two different cultures. So undoubtedly, whether it's you're going under Companies Act, mergers and acquisition, where you're going under ODR, where you're going under ADR, where you're going for litigation, where you're going to NCLT, most importantly, you need to see that you're talking about two different cultures. Okay, and international commercial arbitration beautifully recognizes the concepts of different seats, different venue, okay, the choice of law. So technically they give you one term which I can say is party autonomy. So this cross-border utility is actually being increased very dramatically, very fast, and it is giving you an enhanced pathway. Now, when I'm speaking about these concepts, obviously, like I mentioned, that there are always two sides of the coin. So I will never say that ADR is perfect in nature, ODR is perfect in nature. You should definitely go and opt for this. You should definitely go and opt for that. There are certain challenges as well. So every coin has two sides. In the same way, even these aspects have two different coins. Like when I was doing a kind of empirical research on this topic, the most important lacuna which I found was the lack of trust and trusting this online mechanism. Okay, so people don't trust the system and they are not very comfortable using it. So again, you need to have certain kind of trainings done. You need to pursue people. Okay, are you talking about the party autonomy, Khushi?
Yes, ma'am.
Okay, so the topic is party autonomy. Bhumi, you want to have the name of the cases. Okay, I'll again repeat the name of the cases. Okay, even Stephen want to have the name of the cases and the statutory provisions for ADR and ODR. So I'll definitely, repeat that. I'm so sorry, my chat box was not open. I just opened my chat box. I'll just quickly finish off with these challenges. If you all are open to it, and whatever you have been telling, I'll definitely going to answer at a later stage. So can we do one thing? Whatever doubts and queries which you're having, you can post it on the chat box. If the organizers is okay with it, so they can definitely post it in the chat box. And what I can do, I'll quickly finish off with the topic which I'm discussing, and I'll keep the last 15 minutes where I'll just take up all the questions which is there on the chat box. Okay, with respect to that, Even if you have any further confusions and if you want to reach out to me with respect to these particular matter or any of the corporate matter, the organizers are having my LinkedIn detail. It's Dr. Shivangi Sinha. You can reach out to me. Even if you have any questions at a later stage, you can just drop me a message there and I'll be very happy to guide you. So we'll just keep this exercise open. If you have any confusion, any doubt, you can just post it on the chat box. I'll just quickly finish off with the topics which I want to deal today. And then one by one, I'll be taking up all the questions, if that sounds okay with everyone. Okay. So please let me continue. Okay, so when I am talking about the challenges ahead, like I mentioned, that the most important part of it is the awareness. Okay, we are not aware and we are not very comfortable with this online system. So we need to enhance this particular thing. How the enhancement can be done, I can give you my live example. I am dealing in academics line. Okay, and I am actually working a lot with respect to these online forums. I am working with Bharati Vidyapeeth, I'm working with Symbiosis, I'm working with TCS, I'm working with, there are students who are researching under me at Golden Gate University. So most of the crunch of it is being done online. So what I'm trying to portray over here is that you need to have the awareness and you need to understand the system and you need to trust it. And the moment I say trust it, and when we are talking about artificial intelligence, keep one thing very straight. No matter you're using Chat GPT or using any other softwares with respect to artificial intelligence, but this is the human intelligence which is actually trying to feed all the informations there. So we are at some other level. So make sure that, yes, of course, we have that capacity to grasp everything which is being feeded so that we can use it in a lucid format. So that awareness, that confidence is something which is being required at the end of the day. That is very important, which everyone should persist. Okay, so this is how you can actually create awareness. This is how you can actually trust the online system. Academics, I can say, is the most important forum. If people start teaching the use of ADR, ODR in the academic fields, it is very vital for the people. I do have certain cells which talks about and deals with respect to all the ADR mechanism. So the students are very much aware that, okay, this is a mediation competition. This is how we can take things forward. This is something which is related to ODR. This is how we can take things forward. Okay, so even the students are very much aware. So academics can actually play a very vital role in giving this awareness pursuit. Okay, moving ahead, you need to have digital divide in rural areas. Okay, you just cannot work with urban areas. When you're talking about development, when you're talking about future, you just cannot have one stand and say that, okay, fine, I just want to turn this rural area into ODR hub, and or the urban areas into the ODR hub. No, you cannot do that, because if you're planning that you want to have an hub at the rural areas, half of the people won't be able to understand. They won't be able, aware that what is this particular concept all about. So you need to have a digital division everywhere in the rural area so that you can pull them up with the urban area and you can have a combined division, that this is how we want to execute things. Okay. And obviously, saying this is very easy. You need to have a proper planning. You need to have a proper setup. There are things which are happening, but of course, there are situations where we need to work, or I would say there is a long ladder to climb, even at that stage. Most importantly, one thing for which people go for ADR, ODR, mediation is the confidentiality. Okay, so when I'm saying confidentiality, there are situations where people don't want their matter to get disclosed. And when I say that they don't want their matter to get disclosed, they want to protect their goodwill. And when I'm speaking about goodwill, there comes the picture of the corporate people. And I have given I've given an understanding that why corporate conflicts should go for alternative dispute resolution. Because obviously this is the most easiest method and with the help of confidentiality, you can actually protect the goodwill. So the understanding over here is that when I'm talking about confidentiality, you should have those laws which protect those kinds of data. Again, I'm not saying that we don't have laws. We do have Information Technology Act. We do have the Data Protection Act, which is based on the GDPR, okay, the nexus of GDPR. We do have so many different rules. We have intermediary guidelines. We have so many different things. But still, there are things, there are situations which is happening, and because of it, we always now and then hear some kind of cyber scam, some kind of conflict which is happening. So when I'm talking about confidentiality, it is very important, it is very vital that your these rules and regulations, your legislations with respect to the protection of these confidentiality should go hand in hand. Okay, so that is also one of the biggest challenges which has to be achieved. Next, the most important thing is that you need to have trained mediators and arbitrator. Now that is the need of the hour. When I am advocating this process, it is very important that when I'm advocating this process, the people should understand that how this process works and what is the importance. Suppose there's a mediation happening and suddenly I mentioned that, let's have a caucus. There's a deadlock, let's have a caucus. But the person who's sitting next to me is not understanding what is deadlock, what is caucus, what is happening. Okay. So in that situation, you are not actually taking the mediation process forward how it should be. Okay, just for your information, I just want to say that whenever there's a mediation competition which takes place, and when I train my student for that, I always say that you should be quite aware of these terms. There are so many different things to it because I just mentioned for an illustration. So I'll say that caucus is a situation, it's a deadlock where mediator, when he or she is trying to felicitate the dispute, but it's not happening. So what they do during this deadlock, they hear both the parties individually and separately. Although the facts which is being mentioned, they don't use it during the proceeding because again, that comes into the confidentiality process. Just in the same way in litigation, when we say that it is the privilege of the, client and advocate information or client and advocate privilege, the same thing applies to mediation as well. But those informations can be actually being used by the mediator to come to a solution. So what I'm trying to say over here, that you need to have a trained arbitrator, you need to have a trained mediator in order to have a futuristic approach of these processes. So if an arbitrator is sitting and he's not aware that what is fast track arbitration, or if he is not able to understand that, what arbitration agreement is, or if he is not able to understand that, okay, this is something which we call document only arbitration. Okay. So all these things is something which has to be taken into consideration when we are talking about the training. So you are the future. Okay, when I say you are the future and you have to take things forward, you should be very much equipped about these processes. Okay, Faz, thank you for your question, and I will definitely take up your questions once I am done with the session. Okay, so you all can again keep on posting the questions in the chat box, and I'll take it after like around 10 minutes or so. So that is one of the most important point. Another which is attached to this particular part is resistance from the traditional legal practices. Okay, we are not ready to come out from our comfort zone. Again, that becomes a very huge problem. We are developing, we are bringing out new things. Okay, we are saying that this is new to us, this is something which we should go for it, this is something which we should opt for it. Eventually, what is happening? We are not going for any of it. Okay, what we are doing, we are still going into that traditional process. We are still trying to approach to the people in that traditional forum which we are having, that okay, fine, let's go to the court, let's do these kind of things. We are not ready to adapt new thing. That becomes a huge problem. Okay, so there are various challenges to it. But what I have tried to do is that I just, in order to make you understand into a very simple form, because see, If I'm talking about sections, if I'll speak about the concepts, if I'll speak about the other things, it's already there in your book. Okay. There's no point of you attending this lecture and me giving up the session, because if I'm already speaking up things which is already there in the book, so there's no point in doing. But if I'm trying to draw a nexus of what is the understanding of the concept, what you should know, and what is already there in the legislation and your books, and if you're getting 1% of it, then of course spending this duration is worthwhile for both of us. Okay, it's a give and take relationship, and it's always a learning process which takes place. So my understanding to this particular concept is that when I'm talking about these challenges, the most important thing which you should know is ADR and ODR. Okay, you can consider it as a transformative shift. It is a kind of transformative shift which is happening in the Indian scenarios justice delivery framework. And while I'm endorsing ADR, okay, well, I'm saying about ADR, because we are not talking about the historical perspective, but I've given so many lectures on the history of ADR and everything, I can just conclude in one sentence. Already, I won't be able to provide justice by giving this sentence, but it is having a deep statutory roots. Okay. Because it is having a deep statutory roots, therefore, ODR can be a very good digital frontier which can help in shaping the future of the legal dispute resolution. Okay, and if we try and invest more on these legal infrastructure, if we try and invest more on these digital literacy, if we try and support more on the institutionals which are doing, there is so much of institutional arbitration and everything which takes place. Okay, I'm pretty much sure that India can become a global hub for dispute resolution, especially with respect to commercial and cross-border matters. And when I'm saying this, there are conclusive proofs for that when I'm saying this. Okay, so that has to be an understanding that, standing here, sitting here and giving you a lot of different informations and saying that this happens, you can go and study this section says this section, makes no sense. But if I'm trying to give you the conceptual analysis, because see, these concepts never changes, only the amendments comes into picture, that has to be taken into consideration. So if I'm just speaking for around 40 minutes, 45 minutes, and I'm trying to give you the understanding, okay, and if I'm trying to give you the approach of this timely justice delivery system, because if you will see the analysis, as of 2024, Indian courts underline approximately, I would say, 5 crore pending cases. Okay. And we need to have these growing judicial backlogs come across so that we can have the necessity of ADR. Obviously, there is growth of arbitral institutions going around everywhere. Okay, we have Indian Council of Arbitration, that is ICA. We have Mumbai Center of International Arbitration, MCIA. We have Delhi International Arbitration Center, DIAC. Okay, they all are having standard procedures. They follow a certain neutrality. They have a faster dispute resolution. We have supportive legislations also. Okay, like just I mentioned about the legislation. Arbitration Act itself has gone across, amendments in 2015, 2019, 2021. They are trying to promote a time-bound dispute resolution process. They have introduced arbitral councils. They have introduced graded institutions. They are giving the international best practices. Okay. Just now I mentioned that Mediation Act is giving you a concept called pre-litigation mediation in your civil and commercial matters. It is laying down the structure for community, the court annex mediation. They are recognizing the more stronger mechanism for enforceability. Okay. All these things are only possible when we are trying to support it. So the moment we stop supporting it and the moment we are refraining and we are saying that no, I don't think that I am comfortable with this particular process, I don't think I can go ahead with this particular process, I am very sure that we should work with litigation, then the situation is going to stop there, and the core awareness is going to stop. Okay, so when I'm talking about the future of ADR and ODR as the whole, I would say that if you know the concept of ADR, if you know the concept of ODR, future lies in us. Okay, that is the only concluding remark which I want to give you, because again, I don't want to flood you with extra information which is not required and which is already available. So this has to be a very communicative, lucrative discussion, so that whatever I'm trying to give here, obviously it's a monologue conversation and things become really difficult when you're doing an online lecture, because I don't know, out of 150 students, excluding me 149, how many are actually with me. Okay, so there's no point in giving you excessive information. So this is the concept of ADR. This is the concept of ODR. I've given you a small nexus related to each and everything. And when I'm talking about the future, which is the topic of our today's discussion, I would say the future lies within us. Now, with this, I would take all the questions one by one. I've just tried to make it very simple, very easy for you to understand. Nothing very bookish, just a very concrete understanding of what are these concepts. Okay, so I'll just try and take up all the questions one by one. Okay, if you have any other questions, you can just, put into your chat box. And like I mentioned, if you don't have a question right now, you can even later on approach to me on my LinkedIn, and you can drop a message there. Okay. Online dispute resolution stands for ODI. Yes. Can we have the cases and statutory provisions for ADR and ODR? Okay, I'll give you that. The case laws. Okay, I'll mention about the case laws as well. Can you repeat the keywords that you have used for two different cultures that I already mentioned, the party autonomy? Okay, the startup's name. Okay, I'll do that again. Which ADR method, mediation, arbitration, or conciliation, do you think holds the most promise for commercial disputes in India? As a 7th semester law student, what internships or certifications would you suggest to gain practical exposure in this field? Okay. Very practical question, Faiz. Thank you for this. Now, when I'm talking about the commercial dispute, I just want to say something out of the box which is not mentioned here. If you were with me in this lecture, I mentioned something about MEDAR process and ARB process. Okay, MEDARB. I'll just put it on the chat box so you can actually connect to what I'm trying to say. Technically, what was happening? A lot of people who were involved in the commercial disputes wanted to go for arbitration. Arbitration didn't work out. They used to go for mediation, and vice versa. Eventually, what was happening with respect to the commercial disputes and everything, people were not able to get the problem. Okay, they were not able to get the solution related to the problem which they were chasing. So this new concept landed up, mid-arb and arbit, where you can combine both the process, where you can have just one person who can be a mediator and who can also be an arbitrator. What is this particular process doing is saving money, trying to get you a quicker dispute resolution to it, and it is also giving you the kind of flexibility and time management. So this is the latest process which is into picture. And speaking about the internships and certifications, I would say I always suggest my students keep on writing research papers. So when you write the research papers, you will understand that what are the lacunas, where are we lacking behind, where we can research properly. There are so many certifications which come across with respect to the certified mediators as well. You can definitely opt for that. There are certifications which is coming from these arbitration centers which I mentioned, the institutional arbitration centers. MCIA is coming up, latest certifications. There are different certifications which are also coming through the ministries. You can have a check. You can keep yourself updated on LinkedIn, where you can actually get a lot of information. You can start following the pages of these arbitration institutions because they keep on updating themselves. And you can also mention a post that you're open for doing these internships, and you can actually go and check on their websites because they do take interns. Along with that, like I have mentioned about the traditional approach, there are so many litigation people involved into the litigation, the advocates who are actually dealing with the arbitration matters. So you can actually go and join those chambers where you can get a good exposure on the working of these arbitration and mediations. If you have any more further questions, you can drop me a personal message. I'll be very happy to reach you out. Okay. I'll be joining my, okay, legislation regarding to ODR. I'll just mention it again. I'll be joining my law school soon, and I wanted to ask, what can I do to gain exposure to ADR right from the first year, especially if my college doesn't have any dedicated cell or support for it. Now, this was the first thing which I was trying to mention. Like, I generally do it. I have students from first year to final year who's working under the ADR cell Madhyasthata. We have the page also for it, for at all the social media platforms. We also run a venture for it. But if suppose you don't have any such things which is there in your college, start participating in events. You have mediation competition, you have negotiation competition, you have client counseling competition always coming into picture. And if you want to get more exposure to it, start writing about these things. When you start writing, because any which ways your communication, your drafting plays a very major role when we are talking about law. So you have to be very enthusiastic about writing. Try and do certifications, and yes, of course, internships can give you a greater exposure. Okay, concluding the other questions which people asked me with respect to the landmark cases which I mentioned. The first case which I mentioned was FCON Infrastructure Limited. Okay, that is AFCON, FCON Infrastructure Limited. It is a case of 2010. The next case which I mentioned was Booz Allen and Hamilton. That is the case of 2011, which speaks about matters which can go for arbitration and matters which cannot go for arbitration. The another case which I mentioned was Salem Advocate Bar Association versus Union of India. It's a case of 2005. Salem is being spelled as SALEM. So these are the three cases which I mentioned. I'll just repeat the name again. FCON Infrastructure Limited, Booz Allen Hamilton, Salem Advocate Bar Association. Okay, these are the cases which I mentioned. Speaking about the legal framework. So legal framework, for ADR, I mentioned Arbitration and Conciliation Act of 1996, which has taken its genesis from ancestral model law, and it covers your arbitration and conciliation as a whole. Okay. Second was your CPC, okay, Code of Civil Procedure, that mandates the court to refer the matter to ADR. Okay. Then I mentioned about Legal Service Authorities Act of 1987, which technically governs your Lok Adalats. Okay. Then I have mentioned about Companies Act 2013, specifically Section 442, where they try and refers the matters to mediation and conciliation panel. Speaking about the ODR, the statutory recognition, like I already mentioned, that you don't have a specific statutory recognition with respect to ODR. So we find its genesis from Information Technology Act 2000, specifically with respect to legal recognition of the electronic records and the digital signatures. Then I have mentioned that there are certain amendments which has taken place in the Arbitration and Conciliation Act of 2015 and 2019, which recognizes the use of arbitration. And there are so many Supreme Court e-courts project which is going on, which tries to integrate the virtual hearing and the use of ODR. So these Supreme Court cases or the Supreme Court projects, you can specifically get online as well. So I think by this, I have tried and answered all the questions which is there. Still you have anything? Okay, you can just let me know. How can you relate the concept of ombudsman and ADR? So ombudsman is basically being used in the banking laws. Okay, this is also a kind of ODR, which has been there. Startups, yes, of course. I'm so sorry I missed that. I'll just take that again. So this is basically being used in banking laws. You have your Banking Regulation Act, which mentions specifically about ombudsman, which says that if there is any kind of matter, any banking issues which is taking place, before going into the forum, whether it's the court or the quasi-judicial body, let's try and resolve it before with the help of ombudsman. And of course, it is also one of the third-party dispute resolution situation. I wanted to ask about the opportunities and career path might open for me if I choose ADR as my specialization in LLM. Knowledge is never a waste, Riya. You can definitely go. I have gone through till PhD. Okay, my specialization also lies in dispute resolution, corporate laws. Knowledge is never a waste. So obviously, when you pursue these kind of things and you go for the academics name, then obviously you are adding on to the degree. That is one of the most important aspect. Your CV gets analyzed, your knowledge gets enhanced, and when you are working for any of the forum, obviously academics line is always open for you when you're studying more. But even if you want to go and opt for corporate sector, or if you want to go for and opt for any other sector, degrees plays a very important role, because you will be preferred better at a better situation than the other person who is actually having a graduation degree. So I won't say that the people won't go and fit into the job who is having a graduation degree, but of course you will always hold an upper hand. So I think that is the basic situation which I can give. With respect to the startups which I mentioned, okay, so there are certain startups which basically works, like for example, there are pre-solve 360. Okay. Then there is SAMA. Then there is Quad, that is Center for Online Resolution of Disputes. Okay, Quad. So there are more to it. You can actually find the names of these startups which I have just mentioned, and they have their specific LinkedIn pages as well. So these days you can be very active on these LinkedIn platforms where you can get lot more informations about it. Okay. So by this, I want to, conclude this session. Over to the organizers. Once again, if anyone is having any confusion, which you don't feel that you are, having it right now, you can reach out to me later on my LinkedIn profile. Thank you so much. Over to the organizers.
Thank you so much, ma'am, for sharing your valuable insights on the topic. Thank you, everyone, for joining the session today. I will be sending the feedback form in the chat box. Kindly fill the feedback form to receive your e-certificates. Thank you.